Welcome to the Gambone Law Podcast, brought to you by Gambone Law, a Philadelphia-based criminal defense law firm. This weekly podcast is based on questions that we have received from clients and their families. Our law firm is committed to providing the highest level of professional service through aggressive advocacy and serving as a trusted advisor during a tough situation. To learn more about our law firm, read my weekly blog, watch my videos, or download one of my strategy books, visit gambonelaw.com or call 215-755-9000 24 hours a day to schedule an appointment. This podcast is for information purposes only and does not establish an attorney-client relationship. Welcome again to the Gambone Law Podcast. My name is Alfonso Gambone. As you know by now, if you listen to previous podcasts, every week we discuss legal issues and I respond to questions from clients and their families on particular issues that are concerned or that are concerns to them, and typically their criminal cases. This week, I wanted to try something a little different. I wanted to make more of a response video podcast to some things that I've heard from friends and clients and family. And really what I want to talk about this week is why people believe that the current district attorney's office in Philadelphia is weak on crime, or they're somehow letting criminals walk away, and now that there's some type of relaxed criminal state in Philadelphia, and that has caused the increase in violence and crime that we've seen recently. I want to talk about a few things. So first, I want to talk about the idea of the current DA's office and why I think people are really believe that he is doing something that hasn't been done in the past. You have to understand that the current DA, Mr. Larry Krasner, is a former defense attorney, and people, I think even before he was elected, assumed that because he came from the defense bar, that he was somehow not going to care less than previous DA administrations. And I simply believe that that's not the case. I think that a lot of what he's doing was done by previous administrations, and no one had an issue with it because they, unlike Mr. Krasner, weren't defense lawyers. They were typically people who have been prosecutors in the past for years, and in some case, judges. And Mr. Krasner doesn't have that background. So before he even started working as the DA of Philadelphia after being elected, there was just a spotlight on him. So I want to talk about a few issues that I've seen and heard about. The first is the idea that somehow the DA's office is giving all these violent criminals and lifelong criminals these sweetheart deals, and now you really don't need a defense lawyer anymore because Krasner's in office, and if you commit a crime, you're going to be on the street the next day. And that's simply not the case. First of all, plea deals have been around since the beginning of time, and since the beginning of our founding, the founding of our country. Without plea deals, all cases would have to go to trial, and without plea deals, no DA's office would have the ability to really operate. So if we had a situation where plea deals weren't offered, there wouldn't be any incentive for an accused to plead guilty. And their defense lawyer would simply tell them to go to trial on everything. And it would clog up the criminal justice system in Philadelphia. And even though the Philly DA's office is much larger than the surrounding counties like Montgomery and Bucks and Chester, they simply wouldn't have the resources to handle all those cases. And even if they did, the DAs within that office and the support staff would at some point, most of them become frustrated and leave. ADAs and support staff, for the most part, are underpaid. You have individuals, men and women, who are typically outstanding students, outstanding law students, very good lawyers, very well educated, and yet they're paid much less than attorneys in private law firms and attorneys in private practice. So if you had a situation where these ADAs and support staff are being bombarded with constantly trying cases, constantly in court, constantly prepping for trial, eventually they're going to leave for better paying jobs, or perhaps the same paying job with just less less stress of trying cases. Trying cases, if you haven't done it before, is extremely difficult. It's extremely hard physically, mentally, emotionally. And any person who says that it's not has not tried a case. I can speak from experience that something like a jury trial and even a bench trial, it's a intense process which requires preparation, and something as simple as just messing up on one question can just blow up a case and really send you in a direction that you weren't intending to go. So you have to understand that. So plea deals, there has to be an incentive for a person to plead guilty. And that incentive is typically dropping charges, agreeing to less of a jail term, or some other type of offer like probation in exchange for pleading guilty. Now, there are also sentencing guidelines, which I've spoken about on previous podcasts. I did a podcast on sentencing, which I encourage you to listen to. If you go to gambonelaw.com, my website, there is now a page where all of my previous podcasts are. But getting back to the point with regards to plea deals, the DA's office will evaluate a person's sentencing guidelines and make a plea offer based on those guidelines. They aren't picking these deals out of the sky. They're based on sentencing guidelines and really the judge that you're in front of. Every judge in Pennsylvania, for the most part, has a different sentencing philosophy. Some are former prosecutors, some are former defense lawyers. Some criminal judges have never practiced criminal law and spent the majority of their practicing career prior to being elected as attorneys in the civil world and have no experience in the criminal world. You also have to understand that because judges are sometimes unpredictable, the DA's office has to take into account what could happen if, for instance, a person were to open plea in front of a judge. So all that is taken into account. You have to also understand that when it comes to judges, when a case goes to trial, at that point, it's really out of the hands of the DA's office. And the judge determines all the issues of law, so whether or not evidence is admissible. And the jury, if it goes to a jury trial, would determine all of the issues of fact. So they are the judges of the fact. The judges are the judges of the law. So really, those issues, if a jury were to find a person not guilty or a judge were to prohibit the admissibility of some evidence, that really isn't the fault of the DA's office. That goes back to the judge, and let's give some credit to the defense counsel for coming up with a theory that was persuasive enough to have evidence excluded or to convince a jury that this person was not guilty. The burden is on the Commonwealth, but as I've spoken in previous podcasts, that burden is guilt beyond a reasonable doubt. It is the highest burden allowable under the law. So it's much higher than the civil burden. Most people don't understand that. They fail to understand it, and they simply believe that the DA's office was offering deals because they just wanted to let the person walk away. But you have to understand that before you go to trial, there are a lot of issues that have to be looked at, and that goes back to the credibility of these witnesses. So there are situations where, for whatever reason, the prosecution has an issue with their own witnesses. It could be a credibility issue. It could be a production issue. It could be just simply getting a person to court. And police, again, a lot of my friends are police officers. I never speak bad about police, but as hard as they try, sometimes mistakes are made. And if mistakes are made, those mistakes can lead to evidence being excluded because those mistakes have led to constitutional violations. That is the judge following the law. We may not like it, but that is the law. That is our system. And a judge, if he or she is a good judge, will not include a piece of evidence based on personal beliefs. Unlike a person who's not in court, a judge has to follow the law, regardless of whether or not they agree with it. And the law is based on the case law and the statutes, whether it be in Pennsylvania or New Jersey or any place else. Sometimes people on social media want to say, well, the court got it wrong, or the DA was weak, or the defense counsel was just unfair, or he attacked the witnesses. Well, that's their job. Their job is to obtain a certain result. The defense counsel has an ethical responsibility to represent their client to the best of their abilities. And if it means going after a witness who has credibilities issues, that's what he or she must do. That is our ethical responsibility as attorneys, to represent a person to the best of our ability. If we're not doing that, we're not only not serving the client, we're actually being unethical. So consider that. Also, before people jump to conclusions about the DA's office being weak, typically these people making these complaints aren't in court, aren't lawyers, have never tried a case, never even sat through any of the pretrial motions, the trial, heard any of the evidence, and are only going off of news reports, which are really, really small snippets of the case. You can't go by, even in some cases, the victim's family. In many cases, the victim's family, I understand that they've lost their loved one, but they weren't there when this happened. They weren't in court. They weren't involved in the investigation. And to say that the case was dropped or the DA's office failed to do its job because they didn't get the result that they wanted is simply unfair. It's ignorant. And to classify an entire office as being weak simply because of a few cases that have allegedly fell apart without knowing the full story is not fair to the DA's office. And I can guarantee you that if another prosecutor was there who was a former prosecutor, you would not have the situation we have now in Philadelphia. People wouldn't feel the same way. But because Mr. Krasner is a former defense counsel, everyone has an issue. Let's talk a few minutes about crime and the elements of the offense. The fact that a person is charged with a crime, it's the obligation of the DA's office, being the prosecutor, to prove the elements of the offense beyond a reasonable doubt. And because the burden is so high, that may cause concern that if you go to trial on a case that, even if it appears to be a slam dunk, there may be issues in that case that we may not see, credibility with the witnesses. And because of that, the DA's office may decide to not go after the more serious charge. So, for instance, in the case of a aggravated assault, the DA's office may offer a simple assault plea because, for whatever reason, there's an issue with the case and they may not be able to prove the aggravated assault charge. Take a gun example for a gun case, for example, or drugs. I've heard a lot of people say, well, the DA's office isn't serious about gun crimes. Well, we don't know the circumstances surrounding the stop. How was the person stopped? Did the officer have probable cause to even make the stop? If there was probable cause to stop, did the officer have probable cause to search? Was the search illegal? We may not know that. The DA's office may say, well, this is a borderline illegal search. And because of that, they offer a very favorable plea deal to get some conviction. Because you have to understand that on the flip side of it, if the DA's office knows that this person's constitutional rights were clearly violated, they have an obligation not to prosecute the person. But if it's kind of a questionable judgment call, they can really attempt to obtain a conviction for less of a charge, but still obtain that conviction. And the fact that a person's on probation isn't a free ride. There are many situations where people violate probation. So when a person's on probation, they are under supervision of the court. They have a probation officer. They have to satisfy certain conditions to remain on probation. And if they violate those conditions, they're going to go to jail. So those conditions typically include things like drug testing, maintaining a job, staying away from a certain area. And these are all good things that actually can help prevent violence. So the fact that a person gets probation, don't assume that, well, the person got off easy. Because, again, that requires a person to do certain things. Obviously, probation is a better result than jail, but you have to understand that probation is a sentence, and a lot of times it does work for people. Okay, bail. This is another issue I've seen on social media and in news reports, that the DA's office is simply letting people out before trial who are serious offenders, and somehow this is this is an indication that they're being weak on crime? Well, first of all, if a person's a lifelong criminal, as people are calling them, and this means that they're on probation or parole, if they're arrested on a new offense, they're not going to be out in the street. The probation officer or the parole board is going to lodge a detainer, and that person is going to sit in either county or state prison until the new case is resolved. So as far as a person being a lifelong criminal, that's simply not the case. If a person is on probation or parole, they're not going to be walking around if they've acquired a new arrest while on that probation or parole. The second issue is bail. Bail is not meant to punish someone. And bail, for instance, in Philadelphia County is typically set 12 to 15 hours after the initial arrest. And at a bail hearing, you will have a defense counsel and you'll have a prosecutor. Both make arguments, and those arguments are based on a person's prior criminal history, the person's contact to the community, and things that are happening in the person's life. So as I've stated in previous podcasts, which again are available on my website, gambonelaw.com, a bail argument, your defense counsel has to make arguments based on several factors which would be persuasive to a court. And ultimately, the decision to grant bail and the amount of bail is done by a judge or a magistrate in some cases. And it's not the DA's office setting bail, it's a judge setting that bail. And the defense counsel is obviously going to argue relevant points. So if you have a situation where even if it's a serious crime, but the person has no real prior criminal history, well, the bail will be set less. Because again, the purpose of bail isn't to punish a person for allegedly doing this, because you have to understand that the person, despite what we believe personally, despite what you've heard in the news, despite what you've heard on the radio or read on the internet, the person has a presumption of innocence. And that is the first thing you will hear in court when a case goes to trial, that, ladies and gentlemen of the jury, you are to presume this person innocent until proven guilty beyond a reasonable doubt. So the court has to treat that person like they are innocent. So bail is not based on that. Bail is based on a person's history, a person's prior failures to appear, whether the person's a flight risk. So a person with no prior criminal history, who has strong contacts to the community, who is working, who has a family, bail for that person will be much less than a person who has a violent past. And even if a person has a violent past, the defense counsel can still argue that perhaps that violent past is 15, 20 years old, and since that time, that person hasn't been in any trouble. So the fact that a person obtains bail in a case isn't a strike on the DA's office. Look further. That's the problem I have with a lot of these comments on social media. They're made by people who usually aren't lawyers, have no experience in law enforcement, and are simply basing it off of what they've heard. And that's like going into a hospital and saying, the doctor killed me. And you have no experience in healthcare. You have no idea the analysis that went into that diagnosis. But, oh, the doctor missed my cancer. Or that doctor is no good because he or she killed my sister. Well, you don't know anything about medicine or science. And even if you do, every situation is different. So even if you are a lawyer and you say, well, Krasner's office is being weak on crime. Well, do you really know everything about the case to really say that? And to simply make that comment, and again, it's just pure ignorance. Finally, let's talk about violent crime versus nonviolent crime. The fact that a person's receiving a program like ARD or the AMP program, otherwise known as the Accelerated Misdemeanor Program, or something like Section 17, which I've written blog articles about, or some type of program where a person is not actually being convicted of anything, those programs are reserved for first-time offenders who are nonviolent. You're not going to have a situation where a person walks in and shoots somebody and gets ARD. In most situations, the DA's office will not even offer ARD in a quasi-violent situation. For instance, a person walks in and walks into a bar and punches a person. That assailant will not be offered ARD, even in Philadelphia, despite what people may think, if the victim isn't on board with the ARD. So Usually ARD is for nonviolent offenses. You have to keep that in mind. Please don't think that because of the new DA administration or because Mr. Krasner is a former defense counsel that you don't need a defense lawyer. It's simply not the case. If you're charged with a crime, you need representation. The DA's office, I can assure you, is prosecuting crime. And the fact that they're doing some things that haven't been done in the past with regards to nonviolent offenders doesn't mean that if you're charged with something serious in Philadelphia, you somehow can just go it alone. And that I think they're calling him Uncle Larry is taking it easy now. That's simply not the case. For more information on criminal defense strategies, and if we can help you with your case, I encourage you to visit my website, gambonelaw.com. You can also call our office at 215-755-9000. You may also email me at alfonso@gambonelaw.com. My first name, ALFONSO @gambonelaw.com. We are ready to answer your questions. We are here to help you, and I will see you next week.